Patent law aims to encourage innovation and invention in society by allowing potential inventors to obtain exclusive rights to their invention. But how does the law determine which inventions are eligible for patent protection? This is where the concept of a person skilled in the art comes into play. However, to understand how this concept is applied, we have to look at the process for obtaining a patent in more detail. Section 18 of the Patents Act 1990 provides that an invention is a patentable invention if it is 1. A manner of manufacture within the meaning of Section 6 of the Statute of Monopolies, and 2. When compared with the prior art base as it existed before the priority date, is novel and involves an inventive step for standard patents or an innovative step for innovation patents, as well as being useful and not secretly used before the priority date. However, for now, we'll just be focusing on the inventive and innovative steps. Section 18, subsection 1b(2) and Section 7, subsection 2 of the Patents Act provide that there will be an inventive step unless the invention would have been obvious to a person skilled in the relevant art in the light of the common general knowledge as it existed before the priority date. However, for innovation patents, an invention is taken to involve an innovative step when compared to the prior art base, unless a person skilled in the relevant art in the light of the common general knowledge before the priority date of the claim would consider the invention only varied from the prior art information in ways that make no substantial contribution to the working of the invention. As we can see, the person skilled in the art is relevant to proving whether there was an inventive or innovative step, depending on the kind of patent. The term is defined in H. Lundbeck and Alpha Farm Proprietary Limited as a hypothetical, non-inventive person who possesses ordinary skill, who works in the art or science of the invention. For example, this is Mr. Jones. Mr. Jones owns and operates a farm. Every day, Mr. Jones uses a device drawn by his horse Boxer to plough the earth he uses to plant his crops. This is Napoleon. He works on a different farm to Mr. Jones. Napoleon also needs to plough his fields every day, but he has invented a tractor to do so. Napoleon knows his idea makes farming a lot easier and wants to patent it. This is where the concept of a person skilled in the art comes in. For Napoleon to be successful in his application for a patent, he has to prove that his invention is inventive when compared to the previous art base. For now, we'll assume that tractors are a new invention. So we know that common general knowledge of farming doesn't encompass how to develop tractors. This brings us back to Mr. Jones. Mr. Jones is your average farmer, skilled in his craft, but no more inventive than any other farmer. So for Napoleon to prove that his invention is inventive, he needs to prove that his new creation is a step above something which could be developed by Mr. Jones, who is a non-inventive person possessing ordinary skill in his art. This is the purpose of the hypothetical person skilled in the art, to form a standard which may be used by the court to help determine whether the threshold necessary for an invention to be considered inventive or innovative has been met. In summary, the person skilled in the art is a fictional concept which was developed by the courts to use as a standard which prospective patents can be measured against, and helps the courts determine whether that invention is either more inventive or more innovative than the previous art base as it exists at the time of registration.